Greetings, everyone. All those in India, good evening, and all those joining us from across the world, morning, good afternoon, good morning. And today, JSA presents a conversation with Justice B.N. Srikrishna, more famously known for the report that he wrote, or the committee that he chaired, which wrote the report, which hopefully will guide India to its privacy law. Justice Srikrishna had pointed out that there are three distinct approaches to privacy. There's an American approach, there's a European approach, and there's a Chinese approach. And what he wanted to create and what he created with his committee was, so to say, a distinctively Indian approach to privacy. I would, before we deep dive into the questions and the Schrems 2 judgment, I wanted to ask Justice a personal question. Was his interest in privacy and data privacy something that was a job that was given to him when he chaired the committee, or was this an interest that came out earlier in life? And can you tell us a little bit about your illustrious career and what role privacy played in it?
I don't know if you want to ask about my career. I've been a jack of all trades and master of none. As a judge, I was sitting judge number 2 from the bottom of the list. The junior most had been in office for about a year or so. Suddenly, the Bombay riots took place, and the Chief Justice went through the whole list of seniority. Everybody declined to do the commission work. You remember the famous Bombay Riots Commission. Then when I was asked about it, I said, Chief, I don't know what this means, but I'm willing to do it because I'm always willing to take up a challenge, never mind whether I know it or not. Then, since it was, a religious communal flagration, and I'm known to be a practicing Hindu, probably wearing my Hinduism right on my forehead every Friday with a big tikka. So I said, look, this might be the only problem. And the Chief Justice said, when you don your robes and sit in the court, do you consider yourself a Hindu, Muslim, Christian, or what? I said, none. I consider myself a judge. And she said, that is exactly what you did. Go ahead and do it. And by job, I did it, and I can say with a certain amount of pride that I did a good job of the whole thing. Then of course, I didn't do much as a judge of the Bombay High Court, then Kerala High Court, Chief Justice, and then Supreme Court. After retirement, I was suddenly one day called by the Finance Minister on my mobile when I was having a morning walk and said, Judge, can you take up the chairmanship of Finance Sector Regulatory Reforms Commission? So I said, Mr. Minister, I have no idea of finance. Why don't you ask one of your secretaries to do it? He said, no, this requires a little more responsibility, little more ability to sell the idea so people will accept it without difficulty. I said, very good. Give me some time, let me work on that. And then, yes, I did. There also, I think I did a good job. I earned me a lot of praise. Then similarly, with regard to arbitration committee, and finally, one day after this is very interesting. I was about to leave for New York by a midnight flight, but I happened to be in Delhi. So I had to take a 9 o'clock flight, come here, catch a midnight flight and go. Suddenly the law minister, Mr. Ravi Shankar, calls me up and says, we are forming a committee for data protection. I want you to be the chair of that. I said, I know nothing about data protection, and in any case, I'm going abroad for 2 months. You won't see my face for next 2 months. He said, no, don't worry, sir. On Monday, we have to tell the Supreme Court that we have to establish a committee. That is enough for me. I said, okay. I didn't know. I have no idea of privacy in the sense of like every human being thinks of privacy. You're going to lock your door, draw the curtains before you go to bed. Yes, nothing beyond that. And then I looked into it. I seriously studied the subject, went around, looked at what was happening in the US. Nothing much was happening in the US. In those days, there was nothing there in the US. Then England, then GDPR, South Africa, Singapore, China, of course, yes. And we also studied a little bit of the Estonian law. So ultimately, as you rightly pointed out, things were in 3 different compartments. Either extremely regulated, very heavily controlled, like Russia and China, or extremely liberal in the US model, and probably GDPR a little to the left, but still very controlled. We said, okay, this will not help for us. We need to come out with our own Indian ability to deal with the subject. So we picked up ideas, modulated them to what we thought would be our necessities, had a lot of interaction with people. In fact, I remember 6, 7 cities, we had huge public gatherings, put a white paper on public record, in public domain, asked for comments, scrutinized the comments, just went through them, analyzed them, then again came out with a final report and a bill. And all that happened 2 years ago. And yet the baby is to be born. We are still seeing the travails of the baby being stuck inside the womb.
But I think that's expected, Justice, for something that's so path-breaking. And I think you mentioned the dichotomy or the extreme sort of position that the US has taken, and the US position vis-a-vis juxtaposed with GDPR has been the talk since July 16, when on July 16, the European Court of Justice came up with a ruling for the Schrems II ruling, which I think in many ways questioned the basis of the Privacy Shield, the US-EU Privacy Shield. And a lot of the discussions and a lot of aspects that came out with the ruling, of course, it primarily affected data transfer between EU and the US, but it makes us sit back and think as an Indian or as sitting in India, that we probably have similar, I would say, a similar dichotomy as the US. We probably don't have a data privacy law to speak of as GDPR. We probably have enough government control to survey, or the surveillance control of the government is wide enough. Also, the data protection bill does give exemptions to the government to access data. Post access of data, do EU citizens, and leave EU citizens out, does a citizen or does anybody, data subject, have a right to protect his data, have a right to go to court if the government has taken the data and seek justice? So we somehow, even though it didn't relate to India, we find ourselves questioning how it's going to affect India, the Schrems II ruling, and how it's going to affect business in India. So I would be very interested, and I have read some work of yours and heard you speak on data transfer and how post-July 16, how cross-border data transfer, especially for Indian businesses, cross-border data transfer, especially to the EU, will get affected. And what are things that we need to be careful about? Because we really don't have a law, so to speak of, at this moment.
Yeah, the law has been too long. Of course, there is a reason for that. I agree with you. It's a complex law, something being done for the first time. And in fact, I did, as soon as the report was submitted, the mail was submitted to Parliament, and the Parliament was about to place it in on the house of on the table of the House. Somebody in the media asked me a question, and I said it is too complex to be rushed through with a voice vote in 15 minutes. It's something that needs to be critically examined by a special parliamentary committee. And I think the law minister picked up on that. And then while tabling the bill, he made a suggestion and said it should go to the JPC, and everybody voted. Now the match is in there and to the JPC. See, the only point on which, or rather 3-4 points on which the bill that is submitted in 2018 radically differed from the bill that is submitted by government in 2018 and 19, had 3-4 important points. Remember that we are in a peculiar situation that post-Puttaswamy judgment, right of privacy has been treated as declared to be a fundamental right. And we all know the distinction between curtailing a fundamental right as against other statutory right. So that is why in the privacy bill that we had submitted in 2018, with regard to the state's ability to access individuals' data, we had said that it cannot be done unless there is a parliamentary legislation warranting it, and the parliamentary legislation complies with the triple principles that Puttaswamy judgment laid down, namely a declared objective, the manner of doing it, and also finally the third one is that it should be a proportionate action to depending on what is the harm that is to be taken care of. Now, with all this, we had said that at this point of time, let's put this so that when a bill ultimately gets through the Parliament, Parliament will either have an independent legislation for this kind of surveillance and this kind of wiretapping and data accessing, or maybe they'll build it into this so that it will be a consolidated act, but it should be consistent with the triple principle that Supreme Court evolved in Puttaswamy case. If not, that was liable to be challenged in a court of law, either in the High Court or in the Supreme Court, and Supreme Court will declare it to be constitutionally invalid. Now, when the bill was in the hands of the bureaucracy, obviously the security people dominate the bureaucratic matrix. So they just watered down the whole thing. Now the government on a mere declaration that it is necessary in my sovereign interest or necessary for security purposes or necessary for dealing with criminal investigation, they have been given virtually a carte blanche to access anybody's data at any time. This is really going to be a problem if the law comes out in this fashion. You'll have the same problem that had arisen in the assurance case. If you remember, Shrems has given exactly what we have been saying from the beginning. In fact, my public utterances, if you remember, I kept on saying that, hey, look, why did I advocate local data localization? I said data localization is necessary for one simple reason, that if you keep your data on a server such as beyond my borders, I have no direct access to it. But there are multinational corporations who do business here, collect a lot of data from Indians, and then store the data on a server abroad. I said, take US for example. Anything that is stored in the US is accessible to the US government. They have got enough provisions in the law. They can immediately access it. It doesn't work vice versa. If a US corporation stores data in India, they will not give it to me. First of all, let's assume that it is necessary that you are chasing a suspect as a terrorist or for a terrorist finance. You require his financial records. Now, a US corporation doing business in India will say, I have already kept it in California or wherever else in the US on a server. Sorry, sir, it is not available with me. The corporation may be within my jurisdiction because it has an established office here. But still, honestly, the manager in charge of the CEO here would say, sir, it's not available with me. And I will say, how do I get it? And I'm assuming that there's a good law at the back of it. I'm not contemplating a situation, the government doing underhanded dealing. The government in exercise of a right given by Parliament, which is constitutionally valid. If they want to access, how will they access it? This man will honestly say, it's not with me, it's somewhere else. How do I access? I have no control over California or wherever the matter data is lying. And then the only answer then would be your MLAT process. Your MLAT process, all we all know, like your extradition process, takes infinite number of steps slowly from here, judicial to executive, then diplomatic, and then executive, and then comes back. It takes about 2 years. Can you do that when you're chasing criminals? Can you do that when you're chasing terrorists? That would be absurd. So we found out a solution and said, hey, data localization is necessary. I won't force you to have the whole thing here. Keep a copy here. So if I am entitled to access it under law that is constitutionally valid, I won't hear from you this excuse that it is not available. And I won't access it unnecessarily. This was the way we looked at it. Of course, that gave rise to a whole lot of hoo about it, that the internet was being hacked and chopped into pieces and the freedom of internet, blah, 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 blah. Now, coming back to your question of how does this Scrum judgment affect us? Now look at the reasoning of the European Court. The European Court invalidated the data shield for a simple reason. They said that when the data goes transatlantic, it is accessible to the US people, but it doesn't work reverse way. He said, what is the use of saying that it has the same, because they had this fundamental principle of adequacy test. Adequacy test, all of us know, is that whatever is done for protection of data should at least be available in another country. Then only there is adequacy. Then I will have no problem in transferring data across the border. But this would not satisfy the adequacy test. That is a critical issue on which, of course, there are other issues. I'm not going into them. The judgment set aside this data shield and they impose some stringent conditions if it had to be revived. Now imagine if somebody in Europe has to have a dealing with India. Now the first question will be, does the Indian standard comply with the GDPR standard? Can we say its adequacy test is fulfilled? At the moment, there is no law at all. So the answer is easy. Now, I'll assume that the bill which is placed in Parliament, the 2019 bill, is enacted. Then also there will be a problem because somebody may get, hey, look, it's so easy for government to simply declare that it's necessary for security and take away all the data. Where is the security? This is going to be a real problem that the Indian government will have to face. And unless our parliamentarians really apply their mind to it and find a solution to it which will be acceptable across the board, we are going to have a lot of problems.
Right, I think that's very important. While I'll come to data localization in a minute, but just staying on surveillance for a bit, I think what you are trying to say is that every data subject, or as we call it, data principal under the PDPL, needs to have a right which is exercisable when there is surveillance by the government. And if the data is accessed, they have a remedy that they can apply. And then if there's a harm caused, then obviously there's a tribunal or a court they can go to and get relief over there. So these are important points, and I'm sure the JPC and I'm sure hopefully people hearing this conversation will take into account and consider that. But the surveillance bit brings me to an interesting concept. Yes, we have the terrorism, but there's a whole concept of national interest. And we had just spoken about Chinese and Russian, I would say, data protection that you mentioned. And the recent ban on apps, the Chinese apps, or the apps that, the list of apps that was provided, how does that sort of play out in the context of national interest and surveillance, and how comfortable or not would that action make the business community?
You see, I'm not sure that this ban was really a thought-out ban on certain fundamental principles. I mean, I remember in the high school, if you didn't allow me to share your tiffin box, I would say I will not give you my chocolates. This is precisely what has been done now. Now, there is some kind of a problem going on the territorial sovereignty up north. So, as if, are you telling me that these apps were not being operated in this country for at least a donkey's number of years that I know? So suddenly, how did it become such an issue? It became an issue because there is bad blood. Now, just it can be taken care of if you had a proper law in position. Now, there is no law. So the government jumps up and says, oh, we are going to ban, use their executive danda and say, all right, we are going to ban all Chinese apps. Now, this concept of national interest is something that I have not understood. That is why if you notice, neither in the 2018 bill nor in the 2019 is it a question of national interest. It's a question of security of the country or sovereignty. Now, I don't know whether you can identify national interest and sovereignty as identical concepts. I don't think that is correct. So this is, look, ultimately, let us understand one thing. Every human being or every state is selfish. They want to protect their own interest. Now, this is a good way of doing it. A little bit of arm twisting they are trying to do it. Maybe they want to arm twist the Chinese on this trade issue and get a better deal on the territorial access.
Well, let's then stick to the Puttaswamy, I would say, restrictions on the right to privacy, which, like you rightly pointed out, one, have to be backed by law, two, need to serve a legitimate aim, three, need to be proportionate to the objective of the law, and finally, there have to be procedural safeguards built against the abuse. Correct. So before we move on, let's just see where the PDP bill on these, the latest PDP bill, I mean, where the PDP bill on these sort of principles to restrict the right of privacy that the government has, where do you see it falter? And where do you see the challenges that the bill has on these principles?
The fundamental constitutional principle in this country has always been that as regards restriction on a fundamental right, it cannot be done by an executive order. It has to come through a parliamentary legislation. Please note that, or a legislation by a state which is constitutionally valid. Now, and such a parliamentary or state legislation, in order to be constitutionally valid, will have to necessarily fulfill the three triple criteria that you just now mentioned. Now look at the BDP bill. What does it say? It has three sections, where the general thing is the government may at any time, in the interest on being satisfied that it is in the interest of security, have access what? To entire thing and exempt every section, all or any section of the act from application to its own entities. We made sure that when I say we, I mean the report and the bill, that the data privacy concept would cut across the board, all would be applicable to all government institutions, public sector institutions, and private institutions. Because everybody's had to be protected, their data had to be protected in these three different compartments. Now, government doesn't want it apparently. So by giving, now imagine a situation, the law is passed tomorrow. So some secretary sitting somewhere in Delhi will say, hey, it is necessary for me to access all JSA data. What is your remedy against that? If you ask me, your remedy is to straight away challenge it as unconstitutional. I mean, you people are experts on this more than I do. I know about it. So that is your. But if the law is applicable, then there is a methodology by which you can do it. Today there is nothing. Therefore, your only remedy in all such matters is to either resort to 226 or Article 32 and go before the Supreme Court and take it as a constitutional challenge. And if the constitutional challenge is there, then the Supreme Court will really ask this question, hopefully, whether these three triple tests have been satisfied. What is the objective that you want to access JSA's data? Why are you doing it? How does it serve your security purposes which you are proclaiming? Because your proclamation is in the interest of security of India. How is it that the data not accessed is affecting the security of the country? And what is the mechanism or the methodology by which you are going to do it? Now, does the bill satisfy all this? That is the question. And therefore, when I was asked, I bluntly said that if this bill is allowed to be passed by Parliament, we will be turned into Orwellian state, without doubt. And I still maintain that.
But Justice, when you say a company or a law firm or an institution's data, it's kind of different from personal data of a person.
Your company will have personal data also, no?
So yes, it would, but when you access data of a company, you're actually accessing data which may go beyond personal data, maybe non-personal data, maybe data of other people. But here, I think the PDP bill is more focused really on protecting.
I totally agree with you. I just gave an example. It could be, instead of JSA, it could be Srikrishna as an individual. Take it as my personal individual data. The same argument will hold there. I just gave you because I can see you right on the screen. I immediately jumped on the red. So this is the point that I'm making. Any individual data can be accessed by a very light touch under the bill. And if that is permitted, what are you doing? You are infringing his fundamental right. It is as good as saying that somebody walking on the street can be immediately taken into custody. And you can't do that, can you? And look at the interesting thing. Article 21, right from A.K. Gopalan's case way back in the 50s, till today, various judgments have taken the view that it is very fundamental to human dignity. Article 21 is the right to life itself. And where does the Supreme Court find the right of privacy? It says it stems from Article 21. So what is true of my freedom to walk on the street is equally true, or my freedom to breathe the clean air is equally true for my right of privacy. So it is an exalted right. Why are you forgetting that? We just can't tamper with that on any ground whatsoever, unless the grounds are paramount and capable of being demonstrated to be constitutionally valid. That is my clear stand on this issue.
So I think you raise a very good point, which leads me to my next topic, is about the data and what is this data? And when we are saying that the government has access to the data and we need to use data in a particular way, there are four sort of broad categories of data. There is general data, there's personal data, there is data that may be sensitive because it kind of reveals some information which you would like to keep private and not reveal to the rest of the world. And then there is this new concept of critical, sensitive, personal data. Now, what is this critical personal data? We understand sensitive personal data, but this critical personal data there's no clarity right now, so I'm not putting you on a spot, but it's very interesting because you were sort of instrumental to provide the background. What do you think the government is looking at in terms of this critical personal data? Because if we have clarity on that, we can at least say, and we can move to data localization shortly, but we can at least say that this data, I as an individual should be willing to hand over to the government. If the government has an issue, none of my fundamental rights are affected, the government can take this data. For example, if I'm manufacturing bombs and I'm ready to blast off the Parliament House, that I shouldn't have a right. So, I mean, it's an argument, so I want to understand your view.
Critical data was not envisioned like that. That was not the concept of critical data. Actually, we discussed it. In fact, I formulated the whole idea of critical data like this. I say that there are certain functionaries whose functions are critical to the state. State in the sense of larger sense of international state, not Maharashtra, Tamil Nadu. Now, President, Vice President, Prime Minister, Chief Justice, maybe the 3 Army and Air Force and Navy chiefs, or the nuclear establishment, head of the nuclear establishment. Their personal data is critical because they are carrying out critical functions in the interest of the state. So I said, this data, although it is personal, what is the necessity of keeping it abroad, keeping it alone? That was the concept of critical data. But at that time, it was thought that when we said it, we must either enumerate all the persons or give some kind of an elasticity to the government to add it. Today, Srikrishna can be critical, but tomorrow the government appoints me to some function which is critical, then my data may become. Therefore, either you give a definitional criterion, or you just enumerate it in an annexure or something like that. So at that point of time, we didn't push it and we said, all right, we'll leave it open. And now what has happened is, they have just made it a carte blanche. They have said anything that the government considers critical is to be. No, I think the right way to go about is to give a definition and whatever adjusts them generis. That should be treated as a critical data. Now, I don't think the example you gave is a situation of critical data. That's a situation where there may be some kind of a threat to law and order, and the government, under a warranted parliamentary legislation, have got force access. Whether you are a terrorist or you are manufacturing bombs for yourself or for supplying it to an enemy country or something of that sort. That is easily handled. There is not a question of critical data.
Sure. So right now there is, at least in the business community, there is a lot of, I would say, discussion. There is no clarity. There's a little bit of concern, if I may put it, that what if the data that they are dealing with somehow falls within the category of critical personal data. And this data, from what you have defined, may be, say, just using the example of President Trump.
If the President of India's data is kept in India, you and I will have no objection to them to talk. In fact, we would say, keep it here only, don't take it elsewhere, isn't it? I'm just giving an example. President.
That's right, absolutely. Yeah.
Now, yeah, I'm sorry, I wanted to expand a little on that. You see, you are saying business communities as having a concern. I'll tell you where the concern really comes, not about the critical data. They are not understanding critical data in the sense in which we understood it and we wanted it to be. actually put into legislation. Now, it's open for people to still persuade the government and the JPC and say, okay, you give a definition and whatever falls within definition will be critical. What really bothers me is one of the points which is more difficult than this. You know, when we formulated the report, we said, we are dealing with PDP, that is personal data protection. So when it comes to non-personal data protection, we will issue some other committee, we will not deal with it. In 2019 bill, I called it legerdemain. They surreptitiously introduced one section and say, anytime in the interest of the whatever the government of India's interest or the country's interest or whatever that usual declaration, non-personal data can be accessed. That is where your concern should lie. You see, non-personal data can be of various kinds. Whatever data that a company has is either personal data of its own persons who are working there, or its business strategy, or its financial data, maybe how it's going to source its supplies for the next 5 years. Isn't it? Now, all this is not personal data. Or take the biggest case of IPRs. Now, fortunately, IPRs are protected by separate legislation. So if you remove IPR from the discussion and remove the data of the personnel, what remains? Your business strategy. You may have your business strategy on record for the next 10 years or next 5 years, how you're going to raise your money, how you're going to source your raw material, how you're going to source your for your other expansion projects, how you're going to source your capex. That's individual company as my individual data is. Isn't it? Can I allow this to be taken away by the government? This is exactly my quarrel with the new 2019 bill. The bill is intended to be a personal data protection bill, where they have just added a last section, like 93 or 94 or something like that, where they have added this and then allowed this also to run through. That should be a greater concern for the business people.
I think what you're saying is absolutely right. We don't have any trade secret law in India. And all that you mentioned, business strategy, any information that gives commercial advantage to one company over another, all of that it can be categorized as trade secrets, proprietary information, and all of this really can only be protected by a contract because there is no IPR law protecting it. So yes, that is data that one needs to be careful about. Hopefully, again, a very good point. Hopefully, the government may come up with another law which deals with trade secrets, and then the issue is resolved, or just allows this law to be focused on the PDP or on personal data. Now, the concept of critical personal data actually brings us to the most talked about issue, especially overseas, of data localization. Now, data localization for sensitive data, we still have the concept where the data can go outside for processing, but critical data cannot go out for processing. Now, this particular issue, if we right now don't have a definition, but say we have a definition and say a fair amount of it is being processed in India, then not only will companies require infrastructure, they will require to make a huge investment for this data localization. And that's actually causing a lot of, I would say, discussion, and may actually lose business for India, because I can understand the data that you are talking about. You're talking about data of the Prime Minister of India, the President of India. But if it's the data of the Prime Minister or President of another country, the President of the US and the Prime Minister of UK, and it falls, within the definition of critical data, and it comes to India, and then it can't leave India. It has to just stay in India. So, that's something that people are finding a challenge to deal with. They are trying to see, do they need to make allocations to create a data localization arm? Do they have to make investments for data localization? Because right now, there is no clarity of what is critical data. So do you think there is the definition that probably will come will be so broad that people need to make that investment? How do you think data localization will actually pan out in practice?
Look, data localization in the committee did not recommend that all data should be maintained here. Please note, maintenance of all data generated in India or brought to India for processing would require massive infrastructure, I grant you that. But that is not what we had suggested. We had suggested, I think you have gone off, the video has gone off. Are you able to hear me? Am I good?
Yes, I'm on, yeah.
So that is not what we had suggested. We had suggested that if you are in business within our jurisdiction, you are liable to be overseen by our laws. Now, at that time, all that we need is you kept the servers anywhere else, just keep a reflected copy of that. That doesn't require such a massive investigation. I am in investment. I don't think it requires such a huge infrastructure to have a copy here. And the copy should be constantly updated, that is all. Now, that is one aspect. But what is the other aspect that you are talking about is something that is also worrying me. Now, even though the act has not come into force, the law is not in force, two entities shot the gun. The bank, by exercising their power under the FEMA or under the Reserve Bank Banking Regulation Act, they said all financial data should be locally preserved. That is a larger issue, and that probably is something that is worrying. Number two, TRAI also did the same thing. Now, if every entity gets up and says all the data that pertains to me should be kept here, that is data localization in its magnitude, which might worry every business, every entity which does business here. But what we suggested was simple: that accessibility under a legislation constitutionally banned should be permitted. Now, it can be done in two ways. Now, if every company were to give a solemn undertaking, which is enforceable in law, that if I am called upon to produce the data, I will produce it 24 hours. I don't need data localization. You can solve that problem. Why? Where is the question of investment then? Now, you are generating a lot of personal data and you hold it on a computer somewhere in California or Atlanta, wherever you are holding it. And if I need to access it under a proper parliamentary constitutionally valid legislation, all that you will agree is that within 24 hours you will produce it for me. I don't want all of your data. Let's say I'm looking for only Srikrishna's data. To me matter ends, because I'm investigating XYZ. I'm not bothered about the rest of the persons. This is actually one better way of avoiding surveillance. Otherwise, there will be constant surveillance on all your data. That could be done.
Right. So I think you are touching upon a very interesting topic which comes to mind is globalization, localization, and the whole concept, the advertisement of HSBC comes to mind, that you are a global organization, but you think locally. And it's now I'd be very interested in understanding your views that what is the purpose of the PDP bill? Is it data protection or is it data localization? And the whole concept, I mean, since you've really looked at global laws before you came up with, what should be in India, how do different countries deal with this concept of localization? I mean, is it a very Indian concept? Is it a very European concept? Is this a very Chinese or American? I mean, let's have some global views on this.
Countries like China, Russia, definitely I know, but I don't know if there are other intermediate countries. I'll take China and Russia. China and Russia are always the iron curtain countries. So they say, nothing goes out, nothing comes in without my telling you. That is their attitude in respect of everything, whether it's finance or enforcement of even decrees of arbitration awards or anything like that. Now, let's keep it aside. We don't want to carry on business like that. Now, other extreme is America. America is one-way traffic. Whatever you think, I will access. But what you want to access, yeah, I will not allow you to access. This is the interesting thing. An American company doing business in India will be subject to their laws as well as our laws. But their laws will allow the American government, the federal investigator, FBI or anybody to access all data that is maintained here, even if it is of a local entity. But does it work the reverse way? Can I say the Indian company working there, my fellows will have the access to that? Then they say, no, you can't, unless the American law permits it, you will not allow it. What is this? This imbalance is something that needs to be absolutely dealt with. It is imbalance which needs to be properly taken. Otherwise, look, I mean, gone are the days of your developing and all that. Look, today everybody has a right of vote, a right of being able to do business with some amount of dignity, a right of saying that I am a state as much sovereign as you are. Maybe you have 10 more missiles, I have less number of missiles, nuclear missiles. What difference does it make? You are not going to use it, I am not going to use it. And if we use it, both of us will die, we know that. Therefore, let us be honest about it. And in business, there is always going to be some trade barrier. Which country has no trade barrier? Tell me. Customs, import duties, export duties, what are these? How do you deal with them? You have some kind of a world organization which deals with it. You have CAT, you have got WTO, they deal with it. Then dumping duties are there. You want to dump matters, goods here and flood my market, there are dumping duties available. So this is all methodology by which each country protects its economic status, economic consequences that follow. So nothing about data that's strange about it. Now, if you persuade an American government to say that whatever rights you have with regard to American companies, Indian data available to India, I don't think there is going to be any argument at all. Straight away we can agree to it. That is not going to be possible because they have their own vision. They say that whatever we say in your country should work for us. But when you come here, what we say for your country also should work. That is going to be a problem. And localization was devised as some kind of not a complete answer to it, one way of protecting our interests. And there also not much. As I said, it is easily dealt with. I can't understand this. If you want data to be accessed without consent because of some circumstances under a parliamentary legislation valid according to the Constitution, what objection can you have? Your objection cannot be that it is somewhere sitting 1,000 or 10,000 miles across. So make it available. Well, if you agree to that, matter ends.
Sure, that's interesting. Now, I come to a topic which I find very fascinating.
Yes.
And the Puttaswamy judgment, and maybe all our thinking and conversation has been one way. It's been between a sovereign and a citizen.
Yes.
And the fundamental right that the sovereign provides and the citizen exercises. Now, what about the same right, which for here we are talking about privacy, what about the same right horizontally? So the right applied between private parties. And I'm raising this really post the Delhi High Court judgment in the case of Deepti Kapoor versus her husband Kunal Julka. And where the court kind of said that where the whole question was of admissibility of evidence versus the breach of privacy, and the court said that you still can, the evidence can be admissible even though there may be a claim of breach of privacy. And you know, if the claimant had any other right that they wanted to exercise vis-a-vis the illegal act of recording the conversation, that is something that they could use elsewhere. But the admission of the evidence was upheld. So how do you sort of reconcile the different layers of privacy? Because we've only spoken about it at one level, the sovereign giving a right to the citizens. But what about citizens per se, interacting with each other?
As far as rights of citizens are concerned, the rights of citizens are determined by their relationship. And that relationship is wholly contractual. Now, I go to a shop and I want to buy some goods. So that fellow will ask me my name, my address, my telephone number. I don't know what they want to do with email. They'll bombard me with all kinds of advertisements. So I give it or I do not give it. I give it if I think it is going to be of use to me, and in which case he will take it and use it in order to say that he is going to improve my prospects of doing business with it. Now this is purely contraction. That is why the basic line in any data protection debate has to be consent. Consent is the minimum requisite for transfer of data. But consent is not the all in all. Even having obtained with consent, you have various other difficulties that it should be used only for a time period that is permissible. It should be only used for the purpose for which it is there. So the purpose limitation, the time limitation, and the obligation to maintain it intact, update it properly from time to time, and to delete it when I ask you to delete it. All these go hand in if it's interpersonal or between citizens and persons. So I don't think there is any difficulty on that. But the question of fundamental right does not. There is nothing like enforcing of a fundamental right against a citizen. It's a right which is available, you exercise it. Fundamental right is a concept which is guaranteed as against the state. Article 13 doesn't say contracts will become illegal. It is only a law which will become illegal if it is infringement of a constitutional right. And number two, once again, let me continue. If you remember, some time ago you talked of data subjects. I was the one who strongly objected to it and said, the subject of anybody after the Queen of England walked out of India. So let's say that it is my data, you are taking it. Therefore, I am the principal and you are taking it on some kind of a faith that is you are the data fiduciary. If you notice the two terms, they make the philosophy very clear. You are taking it because you have agreed that you will do it according to what I want and I have given you on the basis of trust. That is how it should work. And if it does not, now Delhi High Court was hampered because there is no law. If there was a law, this argument would, see, somebody went and argued fundamental rights. The question that was argued in that Kapoor case was evidence that has been procured by a breach of my fundamental right not admissible. This argument is no good because this doctrine of the fruit of the poison tree, if you remember in America, any evidence obtained even by a criminal investigation department, if it is not in conformity with the fundamental rights of the citizen, which are they are supposed to teach about the Miranda rights and all that, it is inadmissible. In India, that theory does not apply. The Supreme Court has gone on record to say that this doctrine does not apply. How the evidence was, supposing some documents are stolen from your office and they are sought to be used against you, they are perfectly admissible if they are otherwise admissible under the law. The fact that they might give you a right to prosecute the guy, but no, there is nothing new on it. Admissibility is not an issue at all. Therefore, that is not a great judgment if you want to shake the world or anything like that. That is very much true. Criminal law is applicable here also.
Because this would lead to probably other contractual relationships like an employer-employee relationship.
Right.
It could lead to a tenant-landlord relationship. All three sensitive relationships in India: husband-wife, employer-employee, landlord-tenant, which so much of litigation has occurred and there's so much of jurisprudence on. So probably this issue of privacy may come up elsewhere as well.
No,
sorry.
For a moment. In all such cases, the bill that was drafted in 2018 and probably even under the 2019, there are just exceptions. That if you are required, for example, take a situation. Let's say somebody is working for you for 5 years, quits your employment and wants to join a competing company. That company asks for a reference. Now, your reference will naturally include his data. That is permissible. In two ways it can be permissible, either by legislation or by a contract, saying that when whatever data we have, we will be right within our right to hand to the next employer. I mean, even in common law, it is permissible. All that the Data Protection Act has to say it in terms. That's all.
Sure. Thank you, Justice, on that. We have several questions coming our way. So let me just quickly move to the questions. The first question, let me read, is from Archana Iyer. She says, as per Section 14 of the PDP bill, the government can process personal data without consent for some reasonable purposes, which include whistleblowing. The section further empowers the government to determine, by way of regulation, as to whether the requirement of notice to the data principal is required or not. This could result in systematic harassment of whistleblowers who may expose scams or irregularities. How should this be addressed, and your views on specifically the concept of whistleblowing and the interplay that this current Section 14 has, which kind of negates the whole concept, or at least puts a fear of God in a whistleblower?
See, the point is very simple. That whistleblower has to be given protection and encouraged. Is a given. There is no escape. Whichever country you are, whistleblowers have to be, unless you want to hound them out. Now, it is necessary, particularly in a democracy, that a person who exposes chinks in some governance should be entitled to some protection. Now, only question is, if you have a law which deals with it, the law is what? The law, the way the Section 14 of the PDP bill of 2019 or 18, I didn't get that. That's what I want to be sure. Because I don't have the copies of the bills right now in front of me.
I don't have the bill in front of me either, but I can just ask Archana if you...
Is Archana talking of the 2018 bill or the 2019? Because there's some amount of difference between the two concepts.
I think she's talking about a 2019, but we will ask her to clarify. She'll probably send me a message.
If it's a 2019 bill, then it is still in the hands of the JPC. Point out to the JPC, hey, by this, what you are giving by the right hand, you're taking away by the left hand. What is the protection given to the whistleblower? So yes, that is why I say, instead of all this, have an authority which will go, like, for example, if you have a lot of financial transactions, you have a regulator who deals with it day to day. See, the Data Protection Authority has been envisaged as a regulator in this sector, whose job is to ensure that there is constant give and take with all stakeholders, and the best practices are identified, and later on, after a lot of debate, turned into regulations. Now, if you don't do that, the government will pass any order anytime for any reason. But that cannot be allowed. I don't think that the section needs to, section as it is envisaged in the 2019 would really help in protection of their data privacy.
So you feel the whistleblower may be at risk of being exposed?
Absolutely exposed. And you know what happens in this country to whistleblowers. They are not only subject to litigation, they are even, their heads are chopped off.
Well, I think whistleblowers, including in Germany, as we have seen in the recent past, suffer pretty much the similar
that's what either we say all right, let them all hang themselves, or we give them protection if you want to encourage whistleblowing. Otherwise, they're tremendous risk for them, whether it's in a private company or in public domain, wherever.
So we have a lot of questions coming, and I would encourage everyone to use their chat function to send me questions, because I'm getting some questions on WhatsApp as well. So please use the chat function and send the questions, because it's easier for me to read from there. Firstly, Archana confirms that she was referring to the 2001 bill.
2001?
Sorry, 2019 bill, sorry, my mistake. Yeah. Then we have a question that's come in from Gaurav Sharma. Gaurav Sharma is asking us just 1 second. He's asked two questions. So let me go to the first question. So Gaurav Sharma's first question is regarding employee data, and that the employer probably has a right to processing which does not require employee consent. So he's concerned, why should the employee consent not be required for processing of employee data?
In fact, I say it should be required, because consent is the minimum requisite for processing of data. Now, after that, there may be additional rights. Now, what prevents you from entering into a contract and signing and saying, when I join you, whatever data I give you, you are entitled to process it for my benefit? You can always do that. You can amend your employment. See, till today we don't have this concept. You can, once the act becomes law and applies to the, you can remodulate your contract terms. And you can also say, you as employer, you will have a right to use my data for X, Y, Z. Straight away, you can agree to that. I don't think that
with employees, when they sign an employment agreement, probably that's where the employer may include terms which may either directly or by implication include the processing of data. And like you rightly said, there may be issues where the employer has to share data even after the employee leaves.
Absolutely.
So that is one of those sensitive relationships where a lot is determined by contract and by practice. So we'll come to the next question, which is also Gaurav Sharma's question. And this question, and maybe it's a wider question on non-personal data. And he's really distinguishing your report, the 2018 and the 2019 bills. And he wants to understand how the non-personal data came into the realm of personal data protection. And he wants to also understand what your views are as to how you would suggest regulation of non-personal data and ownership of such data. So which also means, I guess, what kind of rights the data principle has.
Look, according to me, non-personal data have no business to be included in the personal data bill. PDP ought to steer clear of non-personal data because there are a large number of issues with regard to non-personal data, much wider than addressed even by the Chris Governing Committee. Is one answer straight away. I'll say what has been done is nothing short of ledger domain. Ledger domain is nothing but what a pickpocket does. Without you realizing, he puts his hand in his pocket, and the government has done the same thing. Very quietly there, we slipped into it. Section 93 or 94, whatever the last section is. That is my answer to that without any hesitation. Next question. I don't like this term ownership of data because I repeatedly have said ownership involves proprietary thinking, proprietary concept. Now, proprietary is good in respect of material objects. I can say that this is my pen. Now look, the moment I say they bring in a proprietary aspect of ownership, several consequences ensue. If it is something that can be sold, Sale of Goods Act will apply. If it is an immovable property, then the Immovable Transfer Property Act will apply. Now, if I say my name is my data, take for example, my name is my data, I don't think there can be an objection to that. Are you going to say that I can sell my name? I can bail it out to you? Is it possible? No. Therefore, jurisprudentially, according to me, data is not capable of proprietary relationship. Data and the data principle have an intimate relationship which may be monetized for some purpose or the other. But that does not mean there is a proprietary relationship. It is not property which can be lent, sold, mortgaged, or gifted. I can't gift my name to you. That's the whole problem. You see, people keep on asking me this question again and again and again and again and say, now for example, I'll give you a very absurd example. If I say this is my wife, am I saying that this is I'm proprietor of this lady? Or these are my children, am I a proprietor? Are they my physical assets? Please note, it only means that there is this expression my in English is genitive case, which indicates only an intimate relationship in this circumstance. It may also, under certain circumstances, indicate a proprietary relationship. If I say this is my car, or this is my book, or this is my pen. So that is wrong. And what is the other facet of the question? I'm sorry, I went in so much into the jurisprudence that I forgot one thing.
So he wanted you to understand how should non-personal data be regulated?
You see, on non-personal data, you see, the concept of non-personal data as advocated in the report of the NPD committee is there may be a lot of data generated because it is collected by government and its agencies. Now, for example, land record and income tax department or your revenue department or various other departments where you apply for license, permits, etc., etc. Or it may be something that is generated by the government of its own. For example, the government may do some kind of survey for oil exploration, survey for oceanic tides, survey for land records, etc. The third is that is government data that is generated and retained in the hands of individual companies and business entities. Now I go and I make an application to your company and my data will be preserved in your hand. That is your personal, that's my personal data kept in your hand. Now with each of them, you have to deal with this separately, and sometimes the difficulty arises as to where the personal data stops and becomes a non-personal data or vice versa. That is an issue that needs to be carefully handled. Otherwise, see, the difficulty is personal data privacy is a fundamental right. Non-personal data privacy is not. That is why the government is quietly thinking of adding that additional section there in the bill, 2019 bill, and saying, if in the interest of the country, I would be entitled to access all your non-personal data. Because they know that it's not a fundamental right. Had it been a fundamental right, you would be hit by Futsami judgment.
Right. So let's move on to Shiv Single's question. He asks you, Justin, how will regulation regarding consent manager be designed? I mean, you may or may not be able to answer that, but from your perspective, what is the consent manager and how should he be, what should his role be?
I will not go into the very great details, but I'll tell you how the concept can work. What is a consent manager? Consent manager is somebody, let's say, consent manager is like a power of attorney holder for me. Now, I can give a general power of attorney and say, what all my affairs you please manage because I have no time. Or I may say, I'll give you a specific power of attorney that you deal with sale of this property or sale of this entity. Now you have banks managing your trust, you have banks managing this issue. So why can't you have a data manager, consent manager? It's feasible. Now, if you don't like it, stop it and say, sorry, from tomorrow I will not allow you to do this. As long as you have a valid power of attorney in his hand, he can sign on your behalf, he can consent on your behalf. That concept is not unknown to law. It exists in other jurisdictions. All that you have to do is project it into this jurisdiction. No, I'm not going into the details of how it can be worked out. I'm sure it can be worked out if a detail is made. But conceptually, it is sound.
Sure. So we have one very interesting question, Justice. This has been asked by Nagarjun. He says, will decentralization of data through blockchain, especially for sensitive personal data and critical personal data, be the future of how data is stored and to protect it? So I think it's interesting in the concept of now with cloud, with blockchain, with all these concepts, how do you really see the technology is changing so fast? How do you see the PDP bill matching up with localization and other issues?
Sajai, the point is simple. A law has to be agnostic to technology. Otherwise, it will have to change every 6 months or probably even every 2 months. Today's blockchain, somebody might come out with quantum technology, which is already being used in America. Now, we have no concept of what the quantum technology is, at least except for very high-flown, highfalutin experts. Now, you can't change the law overnight because of this. The law can only say, I am giving you the data, keep it safe, whatever technology you like. If it is simple data and you are a Pan BD shop dukan, keep it under lock and key. If you are somewhat better, keep it under a computer and lock the computer at night. If you are a very highly sensitive operating or a very FinSec, then use whatever technology you want to. Use computer technology, but make sure my data remains with you. Unhindered and unobliterated and undiluted. That is all that I say, the law that would say. I am not going to go into the technology at all.
I think the question is that if cloud and with blockchain, we really don't know where the data resides. So that localization concept kind of becomes a little complex. But anyway, we'll see how it's managed as time goes by.
To that also, I have no difficulty at all. You want to keep it in the cloud, you want to keep it in the heavens, I don't care. But when I want to produce it, that's all that I'm saying.
That should be the intent. And that's really because the localization, I think, as a concept is very difficult for business to understand today.
See, that is why I gave you the philosophy behind localization. I need access legitimately, produce it. Don't at that tell me that it is not in your hands. That is all.
I think geography became history long time back, but we still very focused on that. I have a very interesting and a little long question, so I'll read it out from Vishnu Nair. He says, should sectoral regulators be given the ability to determine what critical data should be within their sector? And this really flows from your discussion on RBI, I guess. The RBI has brought this up and also asked that financial data be declassified as sensitive data. Would this complicate the manner in which critical data is to be treated, especially if there are cross-sectorial implications?
See, I told you what my concept of critical data is, what we were thinking. And of course, now the government has kept itself a blank check for itself. Now, if the government were to say functionally define some data and say whatever agism generates would fit into the definition would amount to critical data, this argument or this difficulty would not arise at all. Now, I have not seen the RBI has defined what is critical data. Have they defined? I don't think they have defined, have they? All that they have said is financial data will be maintained here, that's all.
Yeah, they are kind of categorizing financial data as sensitive data and should be probably maintained in India.
That's all right. That's whether it should be done or not is another issue. Now, the RBI is entitled to do all this today because there is no law. If the overarching law on data protection was applicable, RGR could not have done all this. They would have been subjected to this law because that law would override all other subordinate laws. See, the data protection law has one overriding section. It says, notwithstanding anything contained anywhere, this law will operate. Then RBI will have to probably shake hands with the data regulator, come out with some kind of regulations which will take care of the data privacy as well as the regulatory aspects of the RBI. Today they are free like what in the 1930s, the Western frontier in America was shoot first and ask questions later.
So I think this freedom that regulators have is the next question or relates to the next question that Rangam Sharma is asking. And this really relates to when will we have this law? Because he's asking a question, should companies start preparing for the PDP bill or is it too premature? Will we have it in 1 year, 2 years, 3 years? Do you expect an erosion of many of these concepts? Because, you know, things have to change, companies have to prepare. Also, it's not just the law, there will also be secondary legislation that will come about to explain the law. There have to be rules, regulations, maybe notifications, orders. There may be repeals that happen. So what should we be telling clients? When should they prepare? Or when will this law come about?
I know that if you're having a baby, I can definitely say in 9 months it will come out. But I'm not sure of what the JP is going to do and in what terms the legislation is going to be. See, one thing is sure, what we had said in the PDP bill of 2018 was that within the 6 months of the act becoming enforceable by reason of the President's assent, the election authority should be set up so that he can then interact with all stakeholders at various sector levels, come out, glean the best practices and turn them into some kind of regulations which are available to be implemented across the sectors. And then within a period of 2 years from the first date, the entire act may be made applicable either in pieces, by section, or by entirely. For example, how did 2013 Companies Act come out? It didn't come out in one stroke. In fact, only last year, I think the last few sections were implemented. So you can do that. Depending on what is more convenient, you can do. But now in the 2019, they have removed that. They have simply said it will come into force from the date on which the government notifies this, which has two implications. Either the government may overnight notify it with 2 hours notice, which is their habit, or they, they may not notify it for the next 25 years.
So I think, Justice Krishna, you and the audience are in tune, because Anup Kulkarni asked exactly the same question. He's asking, the Companies Act came into force bit by bit, like you said. Will there be a transition, or do you think there is going to be a transition period when for the implementation of the PDP bill?
You see, that could be done. Instead of, I can understand if you think that this is somewhat complex and it requires a lot of rejigging on the part of everybody. So instead of 2 years, make it 3 years if you like, make it 5 years if you like. But say, within the next 5 years, everybody should be prepared to do this. But bit by bit, I'm going to implement the sections. So the Data Protection Authority will get more and more jurisdiction, more and more stakeholders on its board, and more regulations which will be applicable across the state. That can be done, but you can come into operation on the date and notify it. So when are you going to notify? At least tell me when you're going to notify it. It is like saying, nobody knows when I'm going to die. At least everybody knew when I was going to retire, so that I could plan for my future. But if you ask me when I'm going to die, I'd say, I don't know. I'm not sure. I'm still alive. All that I can tell you is that.
The other question Lakshmi asks, and her question is, the 2019 bill introduces the concept of sandbox. It gives the DPA, the Data Protection Authority, the right to modify the application of certain provisions of law for eligible entities that are engaged in innovation in artificial intelligence, machine learning, or any other emerging technology in public interest. The relaxations that may be provided in the sandbox include exclusions from the need for having a clear and specific purpose for data processing, collection only for a specific purpose, and limited period of retention of data. To be eligible, an entity should have in place a suitable data privacy by design policy that has been certified by the Data Protection Authority. However, there's no clarity on the certification requirement. This is a cause for concern for data principles. How can this be addressed? Lakshmi Ramachandran.
All I can tell Lakshmi Ramachandran is simple, that let the act come into force, let the Data Protection Authorities start functioning, then you can put all this to him and he will interact with you people and then come out with celebrate sense to everybody. Today we just don't know what it is. We are worried about how should we name that. Is it going to be a boy? Is it going to be a girl? Should we name him this or should we name him that? I don't know. Let's make sure that the baby is safely delivered. Then we will think of what name you're going to give to the baby. First ascertain which sex it is going to be. And unfortunately, like in medical field, this kind of anticipation is not prohibited here.
So, and we have Mary Julie John is asking us a question about the Arogya Setu app and the use of the Arogya Setu app and the collection of personal data of millions of Indians. How do you look at this and how do you analyze it from the data privacy perspective?
I have already gone on record publicly saying that the Arogya Setu was only illegal and unconstitutional. For the simple reason, it is not backed by any parliamentary legislation. Who issued the order? Under what provision of law? Have you checked the Endemics Act? Have you checked the there are two acts under which they are supposed to be acting. One is the the Epidemics Act, and the other is the Emergency Act or something of that sort.
The
Disaster Management Act. Neither of them has warranted such a situation at all. Now, if they had acted really under any of them by amending the act and saying that this will be a method of stopping the epidemic, I would have agreed. And who issued that? Some council of some kind or anything? I don't understand councils of permission to issue notification under the statute. So I said, who are these persons who issued? They have no business to issue this. And in any case, privacy of my data is my fundamental right. If you are touching my fundamental right, show me the warrant of parliamentary legislation for that. Therefore, it is illegal. And for once, the government responded. They stepped back And they said it cannot be made mandatory. Now it is voluntary. If you want to do it, you do it. Otherwise, you give a self-declaration and you can run through. See, this is the contact ascertainment is good idea, but then don't do it. And the way look the government did it, everybody shall have some kind of a smartphone, and that smartphone should do that. You can't. I don't want to have a phone at all. Why should you force me to have a phone on top of it a smartphone? Why should I invest 60, 70,000 rupees for a smartphone? What is this? So now it is made that is very voluntary. If you want to find, if you have a lack of rupees in your pocket, you can go buy the latest iPhone 11 or 12, 13, whatever it is, and then it will help you link it to somebody else. And all this has to come. My data is going to be accessed. Either you do it by consent or you do a law which permits you, and that law is consistent with the Supreme Court declaration. That is all the bottom line.
So we have another interesting question. I'm not sure if you have an answer for this, but I will surely read it out. Rakesh Warrior is asking, India is projecting itself as an Atmanirbhar Bharat. Is data localization important for achieving this?
Frankly, I don't understand what Atmanirbhar is. Nobody can be really Atmanirbhar unless you are absolutely a philosopher intended only in assignment of God. Then you can be Atmanirbhar. Otherwise, every human being is Nirbhar on somebody else. I am Nirbhar at least on my wife if nobody else, although no servants are available right now because of the pandemic. I am Nirbhar on her, she is Nirbhar on me. So Atmanirbhar means what? That you will not have any relationship with the rest of the world? Does it what Atmanirbhar means? If Atmanirbhar only means that we will produce our necessities as far as possible, then what was Gandhiji telling you? Gandhiji telling was the same thing, no? Gandhiji told you, you have your own charkas, your own village industries. That is Atmanirbhar really. But you want to build missiles for which you are Atmanirbhar. Are we really Atmanirbhar? You want to build Rafale jets, you have to go and buy it from France. So let's keep that discussion a little more malleable to understand what is Atmanirbhar. And that is why I say you don't use a term which is not properly defined. That is, as a lawyer, that is my first difficulty. Whatever term you use, define it. What do you mean by Atmanirbhar? That you will not rely upon anybody, or you will try and make it in your own cottage industry as far as possible. If the first, that is absurd. If the second, good luck to you. That's all the time. If in the villages we can manufacture Rafale jets and atomic missiles, please go ahead and do it. I have no problem with it. I'll be happy.
So we have Satya Narayan asks us another question, an interesting question. Again, what is your opinion on monetization of non-personal data, especially by the government, when we are reading in the press that data is the new oil?
What do you mean by data is the new oil? If I have oil in my well, I can sell it to you. I can give it to you on a loan basis. I can write the well itself to you. I can raise a loan by mortgaging the oil. Can I do this with my data? That is the question I keep asking. You can monetize it, yes. I mean, I gave an absurd example of saying that my wife and children are not my property, who can be mortgaged. But I tell you, it has happened. If you go back to the story of Harish Chandra, poor man had to raise money by selling his wife and children. Are we prepared to do that? That is the question. Therefore, this is the relationship between the data and the data principle. Now, if you want to monetize it, in the sense, you are allowing another person to utilize it for generating money of which you obviously want to share. It's your lookout. I have no problem with it. I have absolutely no problem with it. But then, this analogy of oil is something that bugs me all the time. It's not oil.
I guess the question really comes from all the marketing and all, especially in the online world today, all the data that is required to access subjects, to access customers, to access or to target people in a manner that you are able to sell your products, than just doing a widespread advertising, which may or may not result in the results or the sales that you have. So if you know exactly the target audience which will buy your product or will be interested in your service, and you get that, then you can, your advertising, your spend of money can be more focused. So paying a little bit of money to get that data may eventually help you in terms of actually doing your advertising. So that's probably
Take for example my name and address, or my email, or my telephone number. Now that is given to somebody who sells me goods, right? So that is the intimate relationship between the data and me. I did not sell it to him. Please note, it is not my property which I sold to him. But if he uses this intimate relationship by parting to somebody, because that man will give him some money, 500 rupees for each name that he gives, what has he done? He didn't change it into commodity. Somebody is taking advantage of this primary relationship to monetize on that. Well, if he does it with my consent, fine. If he does it without my consent, the act will take care of it. But that doesn't become proprietary in that sense. That is what I keep on saying. You must understand jurisprudential basis for that.
Right. So before we wind up, I do want to thank Manas for putting this program together, this webinar together. And if Manas has a question for Justice, this would be the time to ask Manas. Manas, are you able to speak now? You had some challenges joining. Are you online, and did you have a question before we wind up the webinar? I'm not sure if Manas can speak. Yeah, Manas.
Sajai, can you hear me?
Yes, I can hear you.
Thank God, finally. So good evening, Justice, and thank you, Sajai and Justice, both of you, for such an intriguing session. And my only question now, I think most of the participants of our session have already asked these questions, but a little off-topic question that I had, and a lot of in-house counsels also do ask us these questions, is that how would the role of a data privacy officer under the bill, how it has been envisaged, would actually help organizations, and what would be roles or responsibility one should play as a data protection officer?
Okay, now the point is this. We have this concept of privacy by design. What does it really mean? Now, prior to the Supreme Court judgment in Visakhapatnam, there was no concept of sexual harassment or prevention of sexual harassment at the workplace. So for the first time, the Supreme Court pushed for it, and then now there is a legislation. What does the legislation require you to do? The legislation requires you to do, put up notices, advise all the women and men employees how they should behave, advocate this concept that the women should be honored at the workplace and not subjected to sexual harassment. Have these special committees which will resolve the complaints. Have this kind of composition of the committee. This is non-sexual harassment by design. Similarly, for privacy by design, you have to do this. Advise, advocate concept of privacy. Each employee must understand that the company is required to maintain privacy. Therefore, it is his responsibility to ensure that the privacy is maintained in everything that he handles. And then educate them on that. That is the concept that is necessary. And therefore, for that you require an officer. Now, for example, if you are a manufacturing entity or have a factory, don't you have a labor officer which is required under the Statute of Factories Act? What is his job? His job is to ensure that the labor and the employers are carrying on hand in hand. His job is to ensure that the requirements of the Factories Act are being met. Similarly, a privacy officer will be doing that job subject to the final regulatory jurisdiction of the sectoral or the state or the central data protection authority all over the country. That is exactly the role. You will have to have, of course, if you tell me that it's going to cost me for doing business, sorry, you'll have to pay for it. And a good company in life.
Yeah.
So we have three more questions, Justice. I don't know whether we have time for them. We have a question on ISP liability. We have a question on children's data, and then we have a long question which I will read out. This is the PDP bill provides for the government mandated sharing of personal data, anonymized or other non-personal data, to enable better targeting of delivery of services or formulation of evidence-based policies by the central government. This is concerning because there is no complete anonymization per research findings. This will violate an individual's right of privacy. This is asked by Archana Iyer. So did you have any views? And then if you have time, you can talk a little bit about ISP liability and children's rights.
About children's rights, we had a lot of debate on that. Because today, children need access to internet. And all transactions on internet are contract-based. Therefore, if I click on, if I access a website, I'm doing it by an implied consent, or sometimes you have to click and agree. Now, with the children, what happens is the minor's contract is void under the law. Therefore, where do you do the distinction? So, unfortunately, the age of minority under the Contract Act is 18 years. And children in their teenagers are deriving a lot of benefit from web programs, web-based programs. Therefore, do we have to deprive them or not? So this is an issue that is going to be more complicated. So do we say, you ask for a declaration and the child will gladly say, I'm 18 years old. Or you say date of birth, children are smart enough to give you an exact date to show them 18 years old. Or do you always say, no, you get a parent's consent. Parent may not be available all the time. So how do we deal with it? Therefore, after a lot of that, we said, no, we'll keep it at 18. Let's let the parliament think about it and sort it out. Now, number 2 question is, with regard to exploitation of children, there are other laws. For example, the POSCO and all that take care of that. The only thing that we tried to analyze and keep in view was this targeting of children by doing something or the other. That can be stopped by treating it as a special case, and the data regulator can put special restrictions on such a. Supposing somebody is across the country and is targeting children by some kind of an advertisement, that activity can be put under regulation. So we call them some sensitive, some special name was given to that term.
Guardian.
Not guardian, we called it some, I forget what it is, 2.5 years ago. Some special name, never mind what the label is, doesn't matter. He is treated as a special entity, special data fiduciary, who will be subjected to strict monitoring by the regulator. That is one way of taking care of the children being subjected to this kind of bombardment of advertisements. And the third is what? Third is, what is the third question?
The question, one more question is on data anonymization and the fact that data anonymization.
Yeah, anonymization is not foolproof today, because what can be successfully anonymized today can by technology be reversed tomorrow. So this is an aspect which you have to keep in mind. But at the same time, we require generic data which is subjected to anonymity in order to carry on statistical processes. Now, for example, if you want to analyze health data and find out what is the impact of COVID in a certain age group or a certain sex group or certain territories, you can do it only by accessing data. But the data need not tell you who has been suffering from COVID-19. It only says 2,000 persons in this area, 1,500 in that area, 2 in this area. That is sufficient. Now, whatever anonymization can be carried out under the technology as it is available today, that should be protected. I mean, you are right. The anonymization is not foolproof. Tomorrow somebody else will come out and say all these anonymous can be de-anonymous. That is why there was a provision in the 2018 bill, I remember, saying that whoever de-anonymizes unauthorizedly will be subject to some kind of a penalty. You took it from me on the ground that you are going to research in statistical research. Then you can't turn it and say whether it is Srikrishna's data or his wife's data or his children's data. If you do that, I mean, it's like the university. You remember when we appear for the university examination, how they have to code and decode and all that. Of course, there are loopholes there, I agree. But then we have to do, this is the best that you can do right now.
So with that, our 90 minutes are over. How time flew, Justice. The conversation was really interesting. And I do apologize to the attendees who've asked questions and I wasn't able to read them. But I thank everyone for sending in their questions. And as I said, I got questions on my phone, on the chat function, everywhere. So thank you. And hopefully the conversation will continue. and we'll have many more opportunities. Thank you for coming. Thank you for addressing the team JSA. And thank you so much, Manas, for putting this show together. All your hard work and curation behind the scenes is much appreciated. Thank you. And for our brand and marketing team and Pavan Yadav for the IT support, thank you all. And once again, thank you, Justice.
Thank you very much. It's nice to be talking to you and having a free-flowing conversation on the subject.
Yes.
Yes. Because I am more interested in the conceptualization. I'm not interested in one section this way or that way. That kind of talk doesn't impress me at all. I think I'm way past that.
I know. And that's why I said that structure should be free-flowing.
Absolutely.
Because I've seen you speak so many times, and I've had conversations with you. It's always more interesting to do it in this format. So I hope the audience liked it, and love to get feedback from our participants. And yeah, I can see some people, Vishal Verma, Gaurav Sharma, all sending their congratulatory mails. So thank you, guys. Let it come through, give us feedback so that we can improve our future sessions, and hopefully we'll have more such informal conversations, which hopefully will result in some knowledge sharing as well.
That's good.
Thank you.
Thank you. Bye.